Okay, well, we're a couple past the hour, so I think it's time for us to get started. Tonight's subject in our twice-a-month webinars here at OJM Group is asset protection planning, both on the corporate and personal side. As a former attorney and the in-house asset protection expert on our multidisciplinary team here at OJM Group, this is my area of expertise, and look forward to sharing this with you over about the next hour. Disclaimer, important for people to understand, anything I'm talking about here is general concepts. It's really, you need to sit with an expert on this who looks at your specific situation. Our firm is not a law firm, even though I was once practicing law for about 15 years. And but certainly, there's, as you'll see tonight, there's a lot of good general information that we can get to you. So let's go on to the next slide. We've written books on these topics, all areas regarding wealth planning, asset protection, tax, corporate structure, benefit planning, investing, insurance planning, etc. We've written them for physicians, as some of as this slide shows. We've also written books in the bookstores for the general public, for business owners, entrepreneurs, investors, etc. And certainly, if you're interested in getting any of our books and you want a free copy sent out to you, then make sure you let us know. At the end of the webinar, we'll have a little poll, and you can make a note that you want a book sent out to you. Today's presentation, we're going to talk about corporate planning. We're talking about protecting cash flow. We're going to talk about personal asset protection. We'll mention shielding assets in a divorce. So let's get started. In general, asset protection planning relates to what we call our sliding scale. Go to the next slide. The idea, you don't ask the question, or the question should not be, am I protected or not? When we're looking at a client situation, we're looking at every one of their assets, and then we're evaluating it from a position either of vulnerability or exposure to a position of protection, and there's a sliding scale in between that. At one end of the scale, and we've used the -5 to +5 sliding scale in our books for over a decade. At one end of the scale, -5 are assets that are totally exposed to creditors. There's no protection whatsoever. If someone had a judgment against you, they could lien or levy that asset the next day. On the other end of the scale are assets that are totally protected from creditors, that are truly exempt under federal or state law. These are assets that even if someone had a $1 billion judgment against you, even if you filed for Chapter 7 bankruptcy, you could keep these assets, 100% of them. And interestingly enough, generally, these are not assets that attorneys set up. So while I said we're not a law firm, in this area, most people think using a lawyer is important, and certainly they are. And we work with lawyers all over the country, either clients' existing attorney, or we make referrals to many firms that we know that do this well and inexpensively. But the tools that protect assets at the highest level are not what attorneys provide. So it's very interesting. Certainly lawyers play a key role in asset protection planning, but if you just go to a lawyer, and I say this as one who used to practice law, and you get the tools that a lawyer provides, you're getting the tools in the middle of the scale. Things like limited liability companies, limited partnerships, trusts, etc. But you will not get the tools that protect you at the highest level. So truly, asset protection delivered in the right way is a multidisciplinary endeavor. It involves legal tools, it involves financial tools, it involves benefit plans, it may involve debt shields, it may involve a lot of different tools that have to be provided by legal professionals, benefit plan professionals, investment professionals, insurance professionals, etc. And if you're only working with one, then you're not going to get the comprehensive plan. And that's one of the things I take pride in our firm, is that we've got all these different professionals in one place. The other concept that's important to understand is the best asset protection is not asset protection. There's a chapter in our books on this. What this means is that if you do something that's clearly designed just to protect assets, it may not do the job. It's very similar to tax planning. If you do something that has no financial benefits, that is purely a tax avoidance strategy that has no economic substance, then it has there's a high risk that if that transaction is audited, the IRS will not respect it. However, if there is economic substance if there are other reasons for doing the transaction other than tax planning, then chances are it will be respected. The same thing here with asset protection. It's not by surprise then that the +5 tools that I mentioned on the scale before are typically those that have significant other benefits. Could be tax planning, could be tax planning, could be wealth protection, wealth accumulation planning, could be benefit planning, could be tax reduction, etc. So typically the best tools, the tools that are +5, are primarily not asset protection tools. Things like qualified retirement plans, fringe benefit plans, non-qualified plans. In some states, your homestead. In other states, cash value life insurance or annuities. These are tools that have complete protection in some states, and in some cases, like qualified plans in every state, but have significant non-asset protection reasons for it. Most people don't live in a home, and like I say, the state of Florida, for asset protection purposes. Most people don't put money in a 401k for asset protection purposes. They're doing it for other reasons, but it has the top level of protection. Next slide. Let's talk about practice protection planning or business protection planning. This could be a medical practice here because we work with a lot of physicians, but as we also see on this slide, a business. Really, it is a private business, just happens to be a medical practice. Often what we'll recommend is not to have just one entity. And this ties in tremendously to tax planning. So next month, Carol Foos, one of our in-house CPAs, is going to be doing 2 webinars on fourth quarter tax saving tips. And one of the things we often stress to clients is not to use in a medical practice or in their business just one entity. Because if you just use one entity, from an asset protection point of view, you're having all your income and all of the assets flow through just one place. If there's a judgment against that one place, then it's vulnerable. 100% of the cash flow is 100% of the assets. But if you split your assets into, and your cash flow into multiple entities, you are thereby protecting it. It's just like what we learned when we were kids, don't put all your eggs in one basket. Many businesses, for some reason, put all their eggs in one basket, but many businesses that are sophisticated do not. And look at our business. We have a number of different types of business lines in our companies. We have over 6 entities in our different business, in our business structure. And all of them protect assets better, and all of them help us save taxes. So not only can you use multiple entities to protect assets, but typically you can reduce your taxes with everything else staying the same because you're using different types of entities, S corporations, partnerships, disregarded entities, C corporations. All of these different types of entities have particular tax benefits. There are things you can do in a C corporation you can't do in an S corporation. Things you can do in a partnership you can't do in an S corporation. So again, if you look at what we do, I have ownership in an S corporation, a C corporation, and multiple partnerships. And they all help me protect assets and save taxes. And so that's something that should be examined in your situation as well. Next slide. In many medical practices, the key asset in the practice is accounts receivable. And this may be true in many other businesses. You don't have to own your accounts receivable in the main practice. You can own it outside just like you would do with real estate, keeping the real estate outside of the business. Most physicians, most business owners get the advice that they should have at least one other entity if they own real estate. Have it in a separate limited liability company, lease it back to the business or to the practice. Same thing can be done with accounts receivable. The same thing can be done with valuable equipment. The same thing can be done with intellectual property like a patent or a copyright. So really the idea is to keep your most valuable assets outside of the operating business and lease it back to the business. And if you do that, if there's ever a claim against the business, especially as a physician with high liability, you're separating it and keeping it outside and protecting it. Next slide. Again, same thing can be done by real estate or intellectual property or equipment. Any valuable asset really can be separated from the business, from the practice, and leased back. So let's talk about cash flow. Probably for many of you on the webinar, your most valuable asset is actually your future cash flow. So what you want to do is maximize the protective benefit plans you can put in place at your business or practice. This not only shields your number one asset, cash flow, because if you can put it in one of these plans, you can asset protect it at a high level, but it also will, in many cases, save you significantly on tax planning. So most people understand qualified retirement plans. Many of you have these, or SEP IRA, profit sharing plan, pension, 401k, etc. The assets that you get 100% deduction and no taxation going into this type of plan. And in it, in every state, it's protected at the highest level. IRAs, most states are protected at the highest level, some are not. And so for some of you, you may be using a SEP IRA, where in your state, you'd be better off using a self-employed KEO or something that is a qualified retirement plan. An IRA is not. It may look like it, may seem like it from a tax point of view, but it's not officially a qualified retirement plan. Section 79 is one type of plan under what we call a hybrid plan. Technically, it's a fringe benefit plan that can be done in addition to a qualified retirement plan. And this type of fringe benefit plan under the tax code will also provide present tax deductions and long-term tax benefits. And in every state, you can design and structure that type of plan for a high level of asset protection. In many of the states, it'll be at the highest level, +5 exempt. In others, you can combine it with a trust or a limited liability company to provide it a very solid +2 level of protection. So both of those tools can provide present tax benefits and long-term asset protection. Other plans as well, non-qualified plans and other types of fringe benefit plans, all can provide tax benefits and asset protection planning. And that's a way to protect whatever cash flow you want to protect and have it grow for you in the future. Now, certainly you're going to need to pay taxes on some of your income, probably a lot of your income, so you can pay your bills. But if your goal is to grow the wealth and you don't need it to fund your lifestyle, then you should be examining how to maximize your contributions into these types of plans so you are growing more because you're getting tax benefits up front. The government's essentially paying you to do it, and you're protecting it along the way. So examining what types of benefit plans you've got, could they be improved, could they be added to, is really an important part of asset protection planning. Again, another example of what typically I didn't do when I was practicing law, because most lawyers don't have good knowledge of benefit plans. It's not on any bar exam. It's not what they teach in law school. So you can't even really get to that knowledge without having, benefit plan experts, and we've got a couple in our firm. Next slide. Qualified retirement plans, digging down a little deeper, there are 401ks, pension plans, profit sharing plans, etc. The asset protection, as I mentioned, is +5 across the board, but there's some negatives to qualified plans from a tax point of view that Carol will be covering next month. The main one is that you pay full income taxation on withdrawal. So while you get a full deduction going in, you're going to pay full tax on the way out. And if you believe that tax rates are going up, this may not be a great bet. Essentially, qualified retirement plans are bets that tax rates stay the same or go down. If you believe that tax rates are going to go up significantly, qualified retirement plan is not a great deal. Doesn't mean you shouldn't use it, but you should understand how it works and the pros and cons of this tool as compared to others. Next slide. And here's what we're looking at. These are the top federal tax rate, just federal taxes, income taxes, from the beginning of the U.S. income tax in 1914. So every year on the decade, so just the data points on the even decade, you could certainly Google up and find all the different data points. But what the point here, I think, is made, which is that for most of the 20th century, the highest marginal rates were well above 50%. In fact, for most of the century, it was about 60%. And that right now, in 2011, we're at the third lowest, highest marginal rate in the history of our tax code. So if nothing else changes, that highest rate is supposed to go up in 2013. And again, you have to look at this and think, does it make sense from a qualified plan, even though it will be well asset protected, to put dollars in? Do I believe that those rates are going to come up or stay low or where they are now? I use my father as an example. I was looking at tax returns of his in the 1970s where he was putting money in a profit sharing plan, as a physician where he was getting a deduction against his marginal rate, which was above 70%. Now he pulls it out in a state that has no state income taxes, and he pulls it out at 35%. Well, that's a great deal. Deduct it at 70, take it out at 35. But what if we're in the opposite position? We're putting it in at 35, but what are tax rates going to be in 30, 40, or 20 years from now, depending on your age? So just understand that qualified retirement plans, terrific asset protection, but understand the tax treatment. And even within the qualified retirement plans, if that's something you want to be doing, you should be looking at how to maximize how much you put in versus your employees. And certainly we have folks on our team that help clients maximize that. There's a lot of formulas that you can use to play within the rules, but give the owners as good a deal as you can do under the regulations. Next slide. Other benefit plans, there's a whole host of different kind of plans, non-qualified plans, fringe benefit plans. Section 79 is one section of the tax code that allows for a fringe benefit plan that allows businesses to put in $100,000. You could put in $100,000 or more per physician, per owner, business owner. So we've got clients who are putting in, well over $100,000 into this type of plan in addition to their qualified plan. It's not a qualified plan, so you can do this in addition to your 401k. This is a fringe benefit plan. And what I like about it is in a group of owners or participants, executives, you can vary how much you put in. So you could have one, let's say, physician who decides I want to put in $100,000 a year. The next one could decide I want to put in $10,000 a year. And that gives you a lot of flexibility. And you also have flexibility on how much you can put in every year. It doesn't have to be the same amount. So, but because you get a partial deduction going in, and then you don't pay tax on the way out, it's a great hedge against not only future income and capital gains income tax increases, but also a great hedge against a qualified plan. So it allows you to options based on your state. So I live in Florida. Florida is the best state in the country for exempt assets. Many of you are familiar with the fact that Florida has an unlimited homestead exemption. So what that means is I can have a $10 or $20 million home with no debt on it. And if you sued me and got a judgment against me, you could not take any of that. You could not put a lien on it. I could actually file for Chapter 7 bankruptcy and get rid of all my debtors, even if I owed hundreds of millions of dollars, and they could not touch one dime of my $20 million home. In Florida, the homestead is exempted. In many states around the country, you have homestead exemptions that are very small. Adam, who's doing this from Ohio, in Ohio, homestead exemption is $10,000, $10,000. And in many states, it is low. In some states, like New Jersey, it's zero. In some states, you have very strong exemptions for financial assets, like a cash value life insurance policy. So in a state like New York, or Florida, or Ohio, in many states, you can have $5, $10, $20 million or more of cash, of investable assets inside of a life insurance structure. And if it's inside of that structure, it's totally exempt from creditors. When those same exact investments, could be funds, could be S&P indices, owned in your own name, would be totally vulnerable. But just by having them inside the cash value insurance structure, the state law protects that. Okay, so you have to take what the state gives you and use that to the extent you can. Okay? Now we're there. Now when no client, even in a state like Florida or Texas, some of the ones with a number of different exemptions, is going to be able to have all of their assets in exempt assets. So while you try to maximize what you can put there, again, I could tell a client, let's say in a state like New York, that has pretty low homestead exemption, only about $100,000 for property values in New York, but they have unlimited homestead, they have unlimited exemption for cash value life insurance. So I could tell somebody, just keep $100,000 in your home, have all of your assets in a cash value life insurance policy or in a qualified plan or an IRA, and you're really +5 across the board. but that's not really realistic. And the rest of our team, the financial planners, the ones who look at cash flow management, our investment team that looks at diversification and asset allocation, say that doesn't make any sense to have all your eggs in those baskets. So we're always going to have to go beyond exempt assets, and this is where the legal tools come in, specifically limited liability companies and limited partnerships. Let's go to the next slide. LLCs and limited partnerships are really valuable because they allow you to invest in almost any asset and allow you to maintain control, and if they're taxed as a partnership, allow you to maintain the same tax treatment, so all the gains and losses just flow through as if you owned it in your own name. So you keep control, you don't lose any tax, you don't have any tax negative to doing it, but if it's properly structured, the entity, and it's used properly and maintained properly, and those are a bunch of ifs, but if all those things are true, you get a +2 level of protection. And what that means is, it's not exempt where the creditor gets nothing, but it's certainly much better than you owning it in your name where the creditor has unlimited rights once they have a judgment to take the asset. Here, again, if it's done right, the creditor should only get what are called charging order rules. This is in the uniform statutes in every state, and for some kinds of assets, you don't even need to use the entity in your state. For real estate, you do, but for investment assets, we manage a lot of money at OJM Group for clients all over the country, and the attorneys typically use a number of states that have really strong LLC or limited partnership rules like Delaware, Nevada, or Wyoming. Very protective. And so you can have almost any asset you want in these types of entities, and you can have control, and as long as there's no problem, you can have access to them. But if you structure them properly, the only thing that a creditor can get is a charging order, and a charging order will not allow them to go inside of the asset, the structure, and be able to take the asset. They won't be able to vote you out as the people who make the decisions. The only thing they're allowed to do is get any distributions, if any come out. But you're still in control of the asset, and you won't make any distributions if there's someone there sitting there with a charging order who has put that in place. And so you can negotiate a settlement. You can say, literally, you're not going to get anything out of here because I'm not going to make a distribution as long as you're sitting there. They can say to you, well, I'm going to sit here for a long time, so I'm going to prevent you from getting dollars out. But especially if you have other assets that are exempt, as I mentioned, if you started with exempt assets, you'll be able to take dollars out of the exempt assets. So you'll still have ways to access wealth if you need it. And you can play the waiting game. And what that does is it allows you to negotiate a settlement. Say, listen, the lawsuits you're concerned about are probably contingency fee type cases where the lawyer only gets paid if they get paid. So you're probably going to have some insurance for some. It might be malpractice insurance, it might be car insurance, it might be umbrella insurance. So what you're trying to do is say, hey, I'll give you a couple more bucks to put this away so you don't have to wait 10 to 20 years to get anything, and I want to settle this out for 5, 10 cents on the dollar. And that's what limited partnerships and LLCs are designed to do. It's not going to be like an exempt asset where you say you get nothing, but it's not going to be the other end of the extreme at -5 where they can put a lien or a levy on the account tomorrow. So this puts you in a strong position of negotiation, which is what I consider a +2 level of protection. Next slide. So this just shows you visually what it's about. If someone was trying to get to the dollars and you had the proper LLC or limited partnership in place and they only could get a charging order, just continue to build out the slide on them. They're not going to get those assets. They're only going to get limited rights, and they're not going to be able to touch the assets. They're not going to be able to become a member. They're not going to be able to vote you out or force a distribution. So that's really the power of the charging order, is it puts them in really a waiting game and allows you to settle something out. Next slide. The key to these, like anything, is in the details. It's making sure the agreement is proper, and even says that. I've seen agreements all the time where it actually allows the creditor to buy into the partnership. So there is no charging order protection because the agreement doesn't say that. It needs to file, and complete the annual formalities and make sure it's doing what it's supposed to do. Ideally, there's a non-asset protection purpose to it. There's some estate planning, some gifting, like we talked about before, a non-asset protection purpose. And the key is working with attorneys who understand what they're supposed to be doing with this and understand the asset protection. We work with a lot of them around the country. But every FLP and every LLC does not have this language in it, I can guarantee you. I not only have done 300 or 400 myself when I was practicing law, but I also probably looked at another couple of hundred to 400 from other attorneys around the country. So I think I've seen really what the best practices is. If you can imagine in your business, just sitting and looking over the shoulder with your physician or another business owner of other people in your business who do a good job and being able to see their work product from 100 different firms around the country, you get a sense of what best practices is. And that's one of the benefits of working with us. Next slide. Protecting the home is a tricky one because LLCs and limited partnerships are not really a good ownership for that. It's a purely personal asset. Most attorneys don't really believe in owning the home in an LLC or a limited partnership, and you still got some capital gains benefits with your home that you would lose in an LLC. You might also incur higher home interest on your mortgage. So and if you have a good homestead in your state, if you're one of the states that has unlimited protection or one of the high homestead states, that's great, but there's only a handful of those. So in most states, putting the home in the spouse's name, if you're just concerned about being sued yourself, is not effective. In some states, it is. A trust is possible, but that really means you're giving it away. So, in certain states, what really we recommend is just not building up a lot of equity in the home, especially with interest rates they are the last 3 or 4 years. You're never going to get cheaper money in your lifetime than your home mortgage at this point. And so if you have extra dollars at the end of the quarter, end of the year, not to pay down the home in a state where you're just building up more vulnerable equity, but take that cash and put it somewhere else, maybe in a limited partnership, maybe in an exempt asset. Your net worth is staying the same, but you're allocating more of your value to better protected assets. And eventually, when the risk goes away, you retire, whatever it is, you can take that value and pay off that mortgage. So we're not saying don't pay down the mortgage and spend the money. We're just saying in states where asset protection for the home is not good, if this is important to you, you want to allocate your additional savings in different places. Next slide. This is kind of a visual concept of that. Next slide. Now, with your non-primary residence, LLCs are terrific tools. This could be a second home. This could be rental property, raw land, commercial, whatever it is. Most sophisticated investors in real estate use limited liability companies, and they're good tools for all sorts of real estate. Asset protection for divorce. Let's go to the next slide here. What works and what doesn't? Well, before marriage, obviously getting a valid prenuptial agreement is certainly a viable tool. In some states, and again, these are a little more restrictive, you can have a valid postmarital agreement once you're married to deal with some of these issues. If you're already married and you don't have either of those, there are some things you can do on a valuation strategy that may make your net worth lower for a temporary period, and in that period, if you get divorced, you're negotiating over a lower value, but the value then comes up because of the way the financial product works. We'll talk about that a little bit. What doesn't work, obviously, is trying to hide assets, gifting, transferring assets for less than fair value when you're married. All of those things are going to be fraudulent transfers. So it's not effective and may get you into trouble. Next slide. Let me make a mention on the valuation play because I thought I'd understand it. What basically we're saying is there are certain assets, benefit plans, financial assets that you might invest in that have a low value because of loads, surrender charges, et cetera, in a particular period of time. So you might put $100,000 into an asset, but in 2 years, because of, and even if it grew to $110,000, if you needed to get the cash out, you might pay, because of a load or surrender charge, only get out $80,000. So even though 100 went in and the value is 110, if you have to get the cash today, it's worth 80. If that's true, then on your balance sheet, you would have 80,000 there. And when you were negotiating divorce, you would split the 40-40. Whereas in 2 or 3 years, that 110 may grow to 120 or 130, And now the surrender charge or load is gone, and so within a couple of years, you've gone from an $80,000 asset to a $130,000 asset. You've only had us pay on 80, but within a couple of years, you've gotten the value of the entire thing. And so that's something I've seen that's effective to some degree in that context when you're looking at valuation. So a little bit about our firm in the last couple of minutes here. I try to keep these to 45 minutes so people have leave some time for questions as well. We're a pretty unique firm because we have so many expertise in-house. We've got attorneys, CPAs, qualified plan experts, non-qualified infringement plan experts, certified financial planners, chartered financial consultants, insurance experts, and an entire wealth management team that has a couple of MBAs, CPA, a PhD. We manage over nearly $200 million for clients across the country. So literally, we can look at asset protection, like I've talked about today, corporate structure, benefit planning, estate planning, insurance, life insurance, disability insurance, long-term care insurance, and all types of investments from hedge funds to stocks and bonds and ETFs and REITs and currencies and everything in between we can look at for a client and do it in a coordinated way. And that's really pretty unique. We have over 1,000 clients in 48 states we've done this for. We can look at both at the business and practice level and personally. And here's something else that's pretty unique. We can offer qualifying clients, clients who have a certain level of income, who have their own business, our firm commitment. And what our firm commitment says that if you go through our consulting process, and our fees typically are somewhere between $3,500 and $10,000, maybe $15,000 on a real large business, to go through our consulting process. But if you've qualified for this, and we'll know this after talking to you before we even decide to think about working together, if we can't show you in our process a way to save at least double our fee in either tax savings and reduce employee benefit costs and asset management fee savings, if we can't show you a concrete, quantifiable way to save at least 200% of our fee, we'll refund our entire consulting fee. So essentially, and we're not allowed to say guarantee or return on investment guarantee, but essentially from a financial point of view, this is we're essentially saying that if we can't show you a way to save what would be equivalent to 100% return on our fee, then we'll refund it 100%. And I have not seen any consulting firm or law firm or CPA firm offer that. And we're able to do that because we're looking at so many different areas. We have the expertise, and so many people are not maximized in terms of all of these things. And I'm just touching the surface. Carol, next month in October, will be doing her webinars on tax planning. We have our wealth management firm. Our people do talks on that, and we have insurance people doing their talks on that. So we're looking at all the different areas, and somewhere in there we're able to find, typically 9 out of 10 times, a lot of value, much more than our fee. So how we work with folks like you who may be interested, everything's free until we decide to work together. So let's have a consult. Let's talk about your particular situation, what's important to you. Obviously, the people who are on today, asset protection, corporate structure is important to them. Tax planning may also be important to you. So much financial planning or insurance products or benefit plans or estate planning. We're not sure, but let's find that out. Let's see if there's a fit between what we do and what your challenges are. And then we determine what the scope of the engagement is. Are we going to look at everything? Are we going to look at particular things? We're doing it at the business level, practice level, personal level. Determine a fee that we think is fair, that we can do it for, see if it's amenable to you. And then see if you qualify for the firm commitment and put that right in the engagement letter so you have that protection there. And then decide that we move forward. And that's a process that's worked for most of us and for many of our hundreds of clients. So as we kind of conclude and get towards the end here, and I'll save some time if you have questions to type them in. This is a question for us, for you. What type of next step is important? It would be right for you. Would you like a free consult with me or one of the members of our team? Would you like a free copy of one of our books? If you like this type of talk, we do talks anywhere from an hour to 2-3 hours at different conferences. We'd be interested in me or one of my teammates presenting at a medical practice or a hospital association, a chamber of commerce, a group of investors, etc. Or if you're not interested, that's fine too. We want to understand who's interested and why. So if you can click the appropriate ones that make sense for you, that would be helpful for us. We'll leave the poll open for another 10, 15 seconds as you do that. Great, let's close that poll up. And then because we have a number of people on, we don't find it effective to have questions in terms of audio, because there's just a lot of feedback and a lot of people on who eventually got on here. So, but there is a place on this to put questions in. If you have any, I'll read the question and answer it. Hopefully some of you said they wanted a free copy of one of our books, either for doctors only, for the physicians, Wealth Secrets of the Affluent for non-physicians. We're offering for the free consult. You can call me, and even if you want to call me right now, it'll go to voicemail, or Adam may be there, and you can leave a message for me. You can email me if you've got a question or you're interested in something and you don't want to have it go out to the group. Feel free to email me, and I'll reply. If not this evening, then tomorrow in the morning. I'll give people a minute to put a question on. Otherwise, if we don't get any, I thank you for attending. I hope you reach out, and some of you take advantage of the free consult and the free book. And as I mentioned, we do 2 webinars every month on different topics. Next month will be tax planning and fourth quarter tax tips. If you want to reduce some taxes before the end of the year, you definitely want to get on and listen to Carol Foose, who's one of our in-house CPAs with over 20 years of tax experience. Thanks again for, we've got a question. One just popped up. Let's see if I can, it says here. Can I put asset protection into play using the tools if I'm already in a lawsuit? Very good question. Yes, you can. Again, the important things about, first of all, we have clients who are always being sued. We've got some real estate developer clients. I mean, there's always some litigation out there. Certainly physicians are always potentially to be sued. But it doesn't mean you're paralyzed if you're sued, okay? The first thing we have to start with is the assets, is the protections that have non-asset protection reasons for them. That's why these exempt assets are so important. That's why the things that save you taxes and that can be implemented at the corporate structure are so important, because if I showed you a way to save $10,000, $20,000, $30,000 a year in taxes by changing your corporate structure, adding different benefit plans, you would do that whether you were being sued or not, because it's a significant benefit for you regardless of the asset protection. That's the kind of thing that can be put in place at any time, even if you're on the way to being to the courthouse, because there's a lot of reasons for doing it other than asset protection. On the other end of the spectrum would be something that has no economic or tax benefit, that's purely an asset protection play, say putting your assets in a offshore international asset protection trust. You're not saving any taxes. You're not achieving anything at the practice. You're not being any financially efficient. You're just doing it to protect against lawsuits. And if you're in the middle of a suit that has some merit, that's going to be looked at pretty skeptically as a fraudulent transfer. So, in between those two extremes, something that's going to save you, a lot in taxes to something that's not going to save you taxes at all, that's clearly an asset protection play, there's a lot in between that you can also do. So I would encourage you, if you are being sued now, to talk to us, because I think there's some things we could probably do to help you for this, and hopefully that claim doesn't go anywhere, is covered by insurance, etc. And you've learned so that now you can put things in place today that will help you going forward, and learn from this experience and put yourself in a better position for the rest of your career and the rest of your life, really. But there are certainly things that can be done. Great. Well, I don't think we have any other questions. That was a good one, but we're about, in my watch, about 8 minutes to the hour. So we've done a good job of getting us done before the top of the hour, and I appreciate everybody attending. Again, feel free to reach out to me by email, by phone, and look forward to speaking to hopefully many of you. Thank you, and have a good evening.